Please go ahead.
Hello, everyone. Welcome to our second session of the webinar series on lawyering with disabilities. We are going to talk about reasonable accommodation and access needs. The reasonable accommodations that are required to be provided under the RPWD Act of 2016. We have with us today Ms. Rama Chari. I hold her in high regard for the kind of extensive work she has done in the field of disability rights. She's currently the director of Diversity and Equal Opportunity Center, and she has been very instrumental in undertaking studies on CRPD as well as the present act and is working towards its implementation. She specializes in disability rights and disability policy. We also have with us today Denise Avant. Ms. Avant is a lawyer from Chicago. She has joined from Chicago to share her experience of practicing with blindness and playing an instrumental role in bringing change in so many different capacities. She is the chair of the Commission on Disability Rights of American Bar Association. She is also the president of National Federation of the Blind of Illinois. Our next speaker is Mr. Salman Khurshid. We are very pleased to have him with us today. He's a senior advocate at the Supreme Court of India and former cabinet minister of law and external affairs. He's one of those very few advocates I know who has a diverse workforce and constantly strives to maintain an inclusive environment in his chamber. We're very glad to have you all, sir. We also have our sign language interpreter, Mr. Nataraja, and we are being supported in captioning by Mr. Ritesh. If you want to pin the video of the sign language interpreter, you can follow the instructions given in the chat message. This is also being streamed live on YouTube. So in case you have to leave the session in between, you can always watch it later. If you have any other access needs, we'll provide an email ID where you can write to us. Or if you think your access need is not being met the way you want, we'll also take care of that. So please do share it with us. Now, Raman is the CEO and co-founder of LawSikho. Had one complaint last time. It wasn't about my twitching, which started all of a sudden and I could not help it. It wasn't about that. He said that I did not share my own thoughts. So I would like to say something before we start with our speakers. So when I used to travel by metro, I used to take a metro or the subway to office, and sometimes I would have a deformed neck or a deformed foot, and sometimes it would happen all of a sudden. I wouldn't know when it was going to come, or sometimes I would take the strain of standing for such a long time, and people wouldn't know that I would need a seat. So when it would start, people would be like, "Where are you going?" I would say office. They would be like, "Office? Why are you going to office? You should be at home. You should take care of yourself." So sometimes people forget that we too have the same kind of aspirations that anybody else would have. And basically we need to earn to survive too. Also, another thing that I keep hearing from my fellow lawyers sometimes would be, why do you come to court? Why don't you just provide consultancy service? You can be at ease, at comfort. And this comes in a context when I have difficulty in, picking up files, holding them in courtrooms. So again, it's like, would you ask an elderly lawyer, like there's no age for retirement for a lawyer. So if you see a lawyer struggling to stand, or if they ask you to offer them a seat, would you say, why don't you sit at home, or why don't you do something else? So what should we actually do is the question, and what does the Act provide? Uh, and should we leave it to the whims and caprices of our fellow lawyers and staff who may not be aware or who may see you as a competition and sometimes even unfortunately rejoice see you struggle? That also happens. So should that be the case, or should there be a system in place to take care of such needs and to provide reasonable accommodation? So what is it? What is reasonable accommodation that the Act requires us to provide? And if you do not provide it, any denial of reasonable accommodation would constitute discrimination under the Act. So to speak further on the subject, we have Ms. Rama Chari. Ma'am, you can begin whenever you are ready.
I would like, hi Sanchita, I would like to share the screen.
Sure. So Ritesh, can you please stop sharing your screen? I think ma'am, it's ready now. You can share your screen.
Good evening, and thank you so much for inviting to this webinar. And I was really glad to hear the introduction that Sanchita gave on the accommodations that are required for people with disabilities in the courtrooms. The topic today is accessibility and reasonable accommodation for lawyers with disabilities. When I was preparing for this webinar, I had a few questions in mind. The questions really were, how many lawyers with disabilities are there in India? What is the percentage of lawyers in the law firms in the country? How many public prosecutors with disabilities are working in the various courts of India? How many law firms have registered their equal opportunity policy as per the Act? Do Supreme Court, High Court, district courts have an equal opportunity policy? Is there a system for lawyers to self-identify and seek reasonable accommodation? And what reasonable accommodation are being provided at workplaces and courts in India? Of course, the answers for most of these questions or all of these questions are in negative. And regarding the number of lawyers with disabilities in the country, it will definitely be very few. I do know of lawyers who are deaf. I know lawyers who are blind. There are quite a few lawyers who are blind. There are lawyers with orthopedic disabilities, and also there are lawyers with certain invisible disabilities, like Sanchita mentioned about her disability. These are people who are working in spite of the system the way it is now. And there would be many instances where lawyers with disabilities may not even been able to enter the system, right from accessing the law school to some of them may have to drop out because they're not getting any accessibility or accommodation in the workplace or in the courts. So I'm so glad that this discussion is happening today. It is a very important topic, and I really hope something concrete emerges from this webinar. So talking of the requirements of the law, the first thing is, who is responsible for providing reasonable accommodation? Here, employers, the law firms that employ the lawyers, corporates that employ the lawyers, government that employs the lawyers, or the organizations that employ the lawyers. It is their responsibility to provide reasonable accommodation. And also the courts. Courts are also the workplaces of lawyers. Hence, it is a joint responsibility between employers and courts to provide the reasonable accommodation. As far as the provisions of the RPWD Act is concerned, the Rights of Persons with Disabilities Act is concerned, Section 3 says equality and non-discrimination, which means, two things here. A person with disability cannot be discriminated on the basis of disability, which means that any person with any kind of disability, whether it is sensory disability, whether it is orthopedic disability, or a person with autism, cerebral palsy, or any other invisible disability, have equal right to become lawyers if they have necessary qualifications. Second thing is that discrimination, the way discrimination has been defined in the Act is that denying reasonable accommodation is also considered as a discrimination. So any accommodation a person with disability requires, it is the responsibility of the employers and the courts to provide. The law also requires employers, all establishments, to frame an equal opportunity policy and submit it with the commissioner. The law requires database of employees with disability should be created and maintained. There is also a rule saying that liaison officer for more than 20 employees, if an organization has more than 20 employees, they should have a liaison officer who is the go-to person for any reasonable accommodation. A grievance redressal mechanism if you're not getting your reasonable accommodation. Building accessibility. Courts and workplaces have to become accessible by 2022. Accessibility of services. The law mandates accessibility of services, and services have been defined as employment, career advances, and access to justice. And there is a separate section, section 12 for access to justice, which talks about right to access courts, public documents being accessible, and so on. So these are the provisions of the Act. What is reasonable accommodation? Reasonable accommodation is basically, there are barriers in the workplaces that everyone is aware of: physical, informational, digital, attitudinal. Hence, reasonable accommodation is required to address these barriers. Of course, there is accessibility, which is more generic, and reasonable accommodation is very individualized. And I have here some interesting picture taken from the Facebook. I'll describe the picture for those who may not be able to see the screen. This has been taken from Facebook. This is basically showing on the left, there is a picture where there is a football field or some game is happening. There's a wall and there are 3 stools on which a tall person is standing in one stool, a medium height person is standing in another stool, and a very short person is standing in another stool. These stools are of same height. So the tall person is having a good time. He is able to see well. The medium sized person is also able to see well, but the short statured person is just not able to see at all. This is basically treating everyone the same. This is not really a level playing field. If you see the right picture, if you look at the tall person does not have any stool, the medium height person has 1 stool, and the short height person has 2 stools. This is very individualized, and this is what is called the accommodation. So a medium height person has 1 stool and the short height person has 2 stools. So some people may need more accommodation. It is not a preferential treatment. To enhance equality, you may need certain support, and some people may need certain high support. And that is individualized, and that is what is reasonable accommodation. And there is also the third picture now, which is very interesting because the wall that was there has been now replaced by a kind of a net. It's a see-through kind of a net. So this is what is the universal design. When you remove these barriers and create a design which is universal design, then no one needs an accommodation. Everybody has an access. So there are no stools required in this. So this is the ideal that we should aim for, and reasonable accommodation when there are barriers. And let's not underestimate the need for accommodations and accessibility, because it provides dignity. It enhances efficiency and effectiveness. Imagine if a lawyer, three people have to lift a person's wheelchair to go to a courtroom, or a person is finding difficulty navigating the place, and it's he or she is asking the colleagues to help, or for that matter, even asking for a seat. These all actually brings down the confidence. And even for clients, you need a lawyer who is confident, and you want to see them effective. So you need to ensure that independence, even for help, safe secretarial support. You need to have system where you can get a secretarial support rather than requesting colleagues to help you. So that is why it's very crucial. You need accessibility and reasonable accommodation. Some of the examples of reasonable accommodations are preference in seating. Courtrooms are generally very crowded, so you need to have certain reserved seating for lawyers with disabilities. Timing, maybe, if I want my cases to be scheduled in certain time. Accessible venue, if the courtrooms are at a higher floor, if I want my matter to be heard in an accessible venue. If I'm a public prosecutor and I need secretarial assistance, that needs to be provided. Interpreters, transcription service, all these are some of the reasonable accommodation a lawyer may need. When it comes to reasonable accommodation, it is very similar to any professional, not just lawyer, but any employee with disability, the kind of accommodations that are required in the workplace. It could be modification to the premises, to assigning a different place of work, providing accessible transport, assistive device or technology the person may need, altering person's working hours, job restructuring and reassignment, modifying reference manuals, modifying interviewing and testing methods, modification and training, providing reader or an interpreter. Like I said, it is very individual. These are just broad places where person may need accommodation. For ensuring equal opportunity, three things are very crucial. One is accessibility, physical and ICT. Second, I spoke at length about accommodation, individualized. Third and most important is awareness. If there is no awareness, then if the judges or the fellow lawyers make fun of you or refuse certain accommodation, then it really doesn't work. So you need awareness. I'll touch upon very briefly about physical access, reaching to the court or reaching to the office, parking and drop off. I have known somebody mentioned to me about in the courts that only judges' cars are, allowed inside. The rest, everyone should drop outside. So you should have a system where people with disabilities can take the car closer to the entrance. Accessible entrance and exits, information boards, signboards, security system, the metal detector, the counters need to be accessible. Lifts, lifts which have voice announcement, the space in the lift, the control panels, the staircases need to be accessible. Courtroom. Sometimes accessibility, when one talks of accessibility, one restricts to ramps and washrooms, but courtrooms is very crucial. Furniture, fixtures, lighting. Sometimes lighting is not really taken very seriously, but it's very crucial. Lot of written material gets exchanged during the time, and a person with low vision finds it very difficult. So lighting should be very good, basis standards. Acoustic. Generally courtrooms are very noisy, and sometimes you can't hear the judges. I've also told that judges sometimes don't use the mics. So you should have mics for judges and the lawyers, and also good acoustic for the room, and induction loop for somebody with a hearing disability to hear well. And all other areas like offices, canteens, washroom, waiting areas, doctor's room, chambers, all of these will have to be accessible. Maintenance cannot be underestimated, because I've known another person I was talking to mentioned that in their court, the lift does not go to the first floor. There is an assumption that people will then climb up to the first floor. So that kind of becomes a huge barrier for a person with disability. Information and digital access. extremely crucial, even more crucial now with the COVID and e-courts and all that happening. They have to be accessible for people with disabilities. I was told e-filing system is beginning, which will be accessible for people with disabilities, which means that it's a big thing because a lot of documents are generally hard copy and you need to have a reader to read out the material for you. With the e-filing system, if the documents are filed which are OCR readable, then it becomes accessible for somebody with print disabilities. So everything which is online needs to be accessible for people with disabilities as per standards. Individualized accommodation, I will not go into the length, I've spoken about it, and awareness of everyone concerned. So coming to what needs to be done, how do you really make this happen? You need to have a policy in place that people, lawyers with disability will get accommodation. Of course, judges and also the witnesses and also, accused, everyone. Guidelines need to be in place for reasonable accommodation. The process, who is responsible? How do you seek and provide reasonable accommodation? Timeline. Sometimes I've seen in companies where you ask for a reasonable accommodation and then it's given after 6 months. So timelines for it. Appointment of liaison officer, which is part of the act. He or she is the go-to person for getting the accommodation. Committee, who decides? Is it an individual who's making decision or is there a committee to decide? Grievance mechanism in place. A communication awareness so that lawyers are aware that you can seek reasonable accommodation. What are this? I'm really looking forward to the next speakers because we would like to know what is happening in America, as well as from Mr. Khurshid as to how we can really push for these things, with the government to announce some of these guidelines as well. We could write to the Chief Justices for accessibility and reasonable accommodation. Maybe we could set up a committee with representations of lawyers with disabilities to draft out an accommodation guidelines and the process specific to courts. Create a bring in a system for self-identification. So if I'm a lawyer with disability, there should be a system where I can share my disability and seek certain changes, and also connect with law universities, because if you really ask me, that is where the biggest barriers are for accessing, um, uh, getting into becoming a lawyer. Last but certainly not the least, what are the rights that lawyers have? First, the rights to request an accommodation at any time, to have his or their medical information kept confidential, a right to refuse an accommodation, to complain if the accommodation has been refused. With right comes responsibility. That is provided only when, you must inform the employer about his or her. Lawyers have to inform the employers about their disability. If they are asked for providing medical information, that needs to be provided. Of course, one has a right to keep it confidential, with on a need to know kind of a basis, provide feedback, and also cooperate if you need to discuss the various alternatives that are available for accommodation. With that, I'll end my presentation.
Thank you so much, Rama ma'am. It was so comprehensive, so crisp, and you also included what should be done about it. Thank you so much. We'll now go to our next speaker and take the questions at the end. Our next speaker is Ms. Denise Avant. Ms. Avant, you can start whenever you are ready.
Good evening, everyone. I'm glad to be with you. It's morning time here in the United States. I want to thank you for inviting me to participate in this seminar. Before retiring in August of 2017, I practiced as a public defender here in Illinois. What that meant was I was an appellate practitioner, and I represented clients on appeal in criminal cases that could not afford to hire their own attorney. Before I came to the public defender's office, I worked in a legal aid office, which is essentially the civil side of what I did as a public defender. There I represented clients who needed help accessing landlord and tenant or public benefits or other types of cases. Now, as you've been told, I am blind. I've been blind since birth. It's important for you to recognize that in the United States, we have a set of laws that prohibit discrimination against people based on their disability. So in 1973, Congress passed Section 504 of the Rehabilitation Act, which prohibits discrimination based on disability in program receiving any federal assistance. So in the United States, schools, colleges, and universities that receive from our federal government for various educational programs any assistance cannot discriminate on the basis of disability without risking losing the funding. Also, in 1975, Congress passed the Education for All Handicapped Children's Act, which is the precursor to the Individualized Disability Education Act, which provides special education services, otherwise what you might call reasonable accommodations, based on the child's needs and disability. Under IDEA, which is now the law, children with disabilities must receive a free and appropriate public education. Now, in 1990, Congress passed the Americans with Disabilities Act, which prohibits discrimination in areas of all areas of public life, including employment, education, transportation, and in all public and private places open to the public. This law is the civil rights law for people with disabilities. A person with a disability has many statutes and court cases to rely on when seeking reasonable accommodations on the job and in special education services in schools. One other critical element that we have in the United States are disability organizations that help advocate whether by providing information about your particular disability to a disabled person or that person's family, or who will go to Congress and advocate for passage of laws in order to ensure that people with disabilities can participate on the basis of equality with our non-disabled peers. As you were told earlier, I am president of the Illinois affiliate of the National Federation of the Blind. The National Federation of the Blind is the largest consumer advocacy organization for the blind in the United States with over 50,000 members. We advocate for blind Americans in so many ways. So for example, we help parents of blind children get the accommodations in education that they need for their children during the individualized education process. The National Federation of the Blind also uses the courts and the legislative process to fight for blind college students to gain access to accessible platforms in the college settings. As we've moved toward a computer and digital environment in educational settings, we find that many times colleges will use products that cannot be accessed with a screen reader or Braille device in the classroom. So we have been fighting for the rights of blind and visually impaired students to get that access. You might also be interested to know that the National Association of Blind Lawyers, which is a proud division of the National Federation of the Blind, has a listserv where blind lawyers and law students can join and ask questions about practicing law as a blind lawyer or going to law school. Now, there are many other groups that do much the same type of work as the National Federation of the Blind does, whether it's a group supporting deaf lawyers or lawyers with autism, or people that need wheelchair access or anything. I was brought up to believe that getting a good education was critical for life's success. I was raised to believe that you need to choose a career you love. Even in high school, I decided that whatever career I chose, I wanted to serve the public, whether working for government, a nonprofit, or something else. Initially, I thought I wanted to major in journalism. However, like many American college students, I changed my major. This was because I took a course while I was an undergraduate in United States constitutional law. This course had an impact on me because it showed how the law could be used to transform our society to treat all people equally and fairly. I was particularly interested in the Warren Supreme Court's rulings that provided constitutional safeguards to those accused of crime. And also I was impacted by the rulings of the court, which helped to promote the civil rights movement of the 1950s and 60s. Now, as part of my education, I received special education service throughout my educational life. During my kindergarten all the way up to high school, it was determined that I would need special education services because it was determined early on that I was legally blind. And so these services included a teacher who specialized in helping blind and visually impaired students by supporting our educational needs. When I was a small child, I could see large print if I got close enough to it. As I grew older, it was harder to read because I started to lose vision. So I had to learn to use Braille. Before the age of computers, my teachers taught me how to type on a typewriter so I could do homework and other print-related tasks. I used tape recorders and books on tape in order to read class assignments. And if the books were not on tape, then I had to use a human reader to read the class assignments to me. While in junior high school, I was taught how to use my cane to travel independently. In the United States, in many of our large cities, we have bus and train transportation. So in order to get to and from a job, you have to be able to know how to use your cane and how to use your orientation and mobility skills in order to get back and forth to work or school. We also have a law in the United States that require that rehabilitation services be provided to further the employment goal of people with disabilities. So in my case, when I went to college, I was supported by the blindness agency by financial assistance for room and board and to pay for tuition, to get specialized equipment to do my classwork, and monies to hire readers when I couldn't get to recorded books. I went to the University of Missouri, Columbia as an undergraduate and also there as a law student. In the beginning of every semester, I would go and talk with my professors and explain the things that I would need. So, for example, if I were in a math class, I would go and talk to the professor and say, I can't see what you're writing on the blackboard. So as you're writing, would you please describe so that I can take down the appropriate notes? I took all of my tests using a braille writer, a typewriter, and a reader to read the questions to me and record my answers. When I was a child, my teachers advocated for me and made sure that I had the things I needed. But as I grew older, they and others taught me to advocate for myself. Once I got to college, I was on my own, though at the school we did have a disability student services office to help you get the things you need. When I took the bar, which is the exam here in the States that every lawyer must take, I again had to explain what accommodations I needed. So for me, way back when, it was simply bringing in my braille writer to be able to sketch out notes and having access to a human reader who could read and write down things for me on the test. I got my first job in 1985 at a legal aid program after sending out many resumes and getting only a few interviews. During the interview process, I explained to the interviewers what I would need to perform my job, and that was a full-time reader back then. I already had a tape recorder and a braille writer and other things to take notes. I was given the accommodation that I needed. Now, in addition to that, the blindness agency was still supporting me to make sure that I had the equipment I needed during the first year of my employment. In fact, my counselor found out about back then what was a new adaptive piece of hardware called a VersaBraille that would allow me to write things in Braille and send the material to a printer. She and my boss then worked together to send me to a week-long training to learn how to use this piece of equipment. When I got my next job at the Public Defender's Office, which was about 2.5 years later, I took my equipment with me, and I, again, during the interview, explained to my new employer that I would need a full-time reader to do the job as an appellate attorney. I have had I had my reader doing just about everything for me in terms of helping me file my documents, reading material, helping me do my research. But in the 90s in the United States, we experienced the computer explosion. Now, in the beginning, the Blindness Agency, in order to help me maintain my job, purchased a computer, a screen reader, which is what is used to read what's on the computer screen. And I myself purchased a scanner and the scanning software to scan and print documents so I could listen to them. Now, as the Americans with Disabilities Act began to take hold, I began to explain to my employer that I would need to have updated technology to help me perform my work effectively and efficiently. And so by this time, all of the lawyers in the office had computers. I just needed my employer to add the software and some of the hardware like the scanner, a Braille display, a Braille embosser, so that I could do that. And my employer did agree to provide those things after much explaining what I needed and why I needed it. Once those things were in place, I could concentrate and do the work that I was hired to do. In the case of, being an advocate for yourself, however uncomfortable it gets, and it can be uncomfortable because, you may be the only person in your firm with a disability. You have to advocate for yourself, because there is no one who knows what you need like you need it better than you do. Your colleagues cannot always relate to you, and you will have to serve as teacher while at the same time being your own advocate and doing your job as an attorney. A person with a disability has to learn to clearly advocate for herself. Of course, you can seek out other individuals and or groups for support, but advocacy begins with you. As a blind person, one of the big things you have to do is determine what you're going to use and when. So in the office, my reader read police reports because those were handwritten and no screen reader can read that. And she would help me with client interviews. In the office, I used my computer to type briefs and motions, and my reader would, at the final stage, make sure that the formatting was correct. When I got to court, I used Braille in the courtroom to help me keep track of the notes that I was taking while I was talking to the judges, the opposing counsel, witnesses, and clients. But my reader would also help me because, as was mentioned earlier, when you get to court, there's a lot of papers being passed back and forth. And so you're going to need someone who can tell you what's on that paper instantly. So that's where your reader come in. You really have to acquire all of the tools before you can decide which one to use. And you have to engage sometimes with the court. I remember when the appellate courts here in Illinois first started to really hold you to a standard of saying you only had 15 minutes, I contacted the clerk of the court, the appellate court, and the Supreme Court when I had my one argument before the state Supreme Court to say, okay, you're turning on a red light, but I'm blind, so I won't be able to see that. So sometimes the judges, when my time was almost up, they would tell me, you have 5 minutes, counselor. You have 2 minutes, counselor. In my oral argument case, the bell would ring at the 2-minute mark. And then when I had only 30 seconds left, the bell would ring again. So you have to be willing to go to the courts and explain your needs. Now, finally, I want to say that when I came to the public defender's office, my reader helped me with everything. But because of the computer explosion, by the time I left, I could do 70 to 80% of the job on my own. I still needed a reader, but I could do my own legal research using a computer, and I could type all of my own documents. The American Bar Association, as you know, I mentioned several groups who are instrumental in helping advocate for people with disabilities. But I count that the American Bar Association, which is the largest lawyers group in the world, also plays a key role by supporting efforts of disabled law students and lawyers to enter the profession. I came to the Commission on Disability Rights as a commissioner in 2012, and I served for 3 years before leaving to participate in other commissions within the ABA. I'm now at the end of my first year as the chair. But the commission has been around since the 70s. It has evolved over the years. Prior to 2011, the commission was focused primarily on mental health issues and gathering case law to support lawyers practicing disability law. But in 2011, the commission determined that it could and should do more. It was decided that lawyers with disabilities and law students needed to be highlighted. In other words, we had to get out before the public and demonstrate our capabilities. And so the commission would put on various regarding legal issues and disabilities. There would be symposiums, and we also created a toolkit for entities to use to create accessible meeting environments. We collaborate with groups interested in opening up the legal profession to people with disabilities. At our annual meeting, we have the Paul G. Hearn Award given to a lawyer or an organization that advances the cause of people with disabilities. We give a champion of disability inclusion law firm disability award to law firms and corporations that have made measurable progress in recruiting, hiring, and retaining and advancing through promotion lawyers with disabilities in leadership position. One of the things that we see here in the United States is when in law firms, if they have disabled attorneys, it's an attorney who is already a partner and has become disabled. we don't have any statistics showing the hiring process, but we do believe that most of the time, most firms do not hire people with disabilities right out of law school. We have engaged in the Disability and Awareness Employment Month to focus on the talents of lawyers with disabilities. That way firms can see what we can actually do. We asked the firms to sign a pledge for change that, to show their commitment to hiring, recruitment, and retaining and promoting lawyers with disabilities. The commission has successfully promoted the passage of resolutions within the ABA to urge the Law School Admissions Council to make sure that they provide reasonable accommodations during the test-taking process for admission to law schools. Some years back, we successfully advocated for the proposition that the bar admittance entities should not use a lawyer's mental health background against them during the character and fitness phase of the admission process. Last October, there was a symposium at American University, Washington College of Law, which focused on the law school environment and the path for law students to get into the employment field. We're currently working on a project to celebrate the 30th anniversary of the Americans with Disabilities Act. As I sit here this evening, I would say that the biggest thing I had to fight against was low expectations. People without disabilities don't necessarily believe that people with disabilities are their equals when it comes to things like raising children, teaching school, or practicing law. We as disabled people cannot fall victim to low expectations. Every day we have to be prepared to exceed these low expectations, and we do that by excelling in our profession. I want to thank you for allowing me to speak to you, and I'll be happy to answer any of your questions at the end.
Meeting information buttons. Activate. You are using enhanced encryption buttons. On custom live streaming. Mute currently unmuted. Alt+A buttons. Activate. Press spacebar.
Thank you so much, Denise, for such a vivid account of your experiences, the development of disability law till the passing of ADA, as well as how the commission contributes in supporting the lawyers with disabilities. Thank you so much. You talked about the pledge that employers are encouraged to sign. I would here like to share that pledge with you, that that's also available in the commission on commission's website. If Ritesh can allow me to share the screen, please.
Okay. Okay, I think you have that, right?
Yes, I'll just share.
Okay, go ahead.
So this is the pledge. The pledge for change, disability, diversity in the legal profession calls on legal employers to affirm that their commitment to diversity includes people with disabilities and to encourage others in the profession to make this commitment. People with disabilities are the nation's largest minority and can be found in every segment and social strata of our society. They are our colleagues, bringing a wealth of experience, perspectives, and talents. Sign the pledge and join the law firms, corporations, bar associations, judiciaries, and law schools who have affirmed their commitment to enhancing inclusion and opportunities for lawyers with disabilities. What pledge signatories can do? Start an affinity group, mentor law students with disabilities, conduct disability awareness, elimination of bias trainings, hire an intern with a disability, offer scholarships and fellowships for law students with disabilities, support disability organizations, partner with businesses and community leaders, collect disability demographic data, increase the recruitment, hiring, retention, and advancement of lawyers with disabilities in the legal profession, and inspire others to sign the pledge. There's another document actually, which is also useful. This is the pledge for change. Disability diversity in the legal profession, a pledge for change. As legal employers, chief legal officers, law schools, state and local bar associations, judges, court administrators, hiring partners, and hiring personnel in the legal profession, we hereby affirm our commitment to diversity in the legal profession, including diversity with respect to individuals with mental, physical, and sensory disabilities. Our pledge is based on the need to enhance opportunity in the legal profession and a recognition that the legal and business interests of our clients and the populations we serve require legal representation that reflects the diversity of our employees, customers, and the communities where we operate. In furtherance of this commitment, this is intended to be a pledge for change for the profession generally, and in particular for our law departments, firms, agencies, law schools, state and local bar associations, courthouses, and organizations. We further pledge that we will encourage other law departments, firms, agencies, law schools, state and local bar associations, court systems, and or organizations that we do business with to make a similar diversity commitment. You have the name of the organization, printed name, signature, and you take this pledge. So I'm done with the sharing. Can Ritesh come back? Thank you so much, Denise. We'll now go on to our next speaker. We'll have a discussion at the end. Our next speaker is Mr. Salman Khurshid. Thank you so much, sir. Over to you whenever you're ready to begin.
Thanks very much. The discussion thus far, or the presentations thus far, have been remarkable and outstanding. And I feel at a great disadvantage to not be able to add any particular dimension to what has already been placed before us, except to say that I have, as a practicing lawyer, I have had some experience of how effective people with disabilities can be in contributing to the legal system. I also have, and I believe I'm greatly privileged to have worked with two of the most brilliant minds in Oxford when I was a student there, and then I became a lecturer. So I was part of the faculty that they belonged to. Professor Cross, and Professor Cross, who is the world's leading expert, as it were, on criminal law, and particularly evidence. There were other people who were obviously very clearly influenced and inspired by Professor Cross, who then dealt with other areas of the law. And I must say that it was remarkable having to work with somebody who would be completely up to date. I mean, we at that time, law reports, there was a section in the London Times that used to give the Times law reports, which were indeed the latest judgments that had come from the High Court and the courts above, and that we had access to them because they came in the newspapers. But before we could actually read some of those reports, we would have in the lecture room or in the tutorials Professor Rupert Cross actually analyzing them. And that was, I mean, that really was a remarkable experience. But I still now, despite decades of having practiced in law and having been through these really real, if you allow me to say, an eye-openers, do I know that we are able in our country to absorb entirely the contribution and the capacity that people with disabilities, so to speak, have to offer to society and to the system. And I would say largely that is perhaps lacking. We just haven't done enough. And I think we haven't done enough for a variety of reasons. One is that we still need an enormous attitudinal change. We need attitudes to change. We need ordinary people or people involved in institution building or institution management to be more sensitized and to be persuaded that this is something that we are missing out on only because we haven't tried to be a little more open, proactively open to their contribution. The second thing is that I believe, and we've just heard on the remarkable backup, support, and the institutional structures that are provided in the United States of America. It's a richer country. It's a country with much more resources that we have, but I don't believe that we cannot in this country find the resources to a similar extent to provide the same kind of support base, starting from the teaching schools, from the law schools, universities. Certainly, why not starting from high schools and bringing people up all the way up to the courts where they can make this contribution. But I think there's an element here, and the challenge, I believe, is a lot to do with technology. The mention that Denise made about the facilities that had been provided before the computer age exploded, and sometimes one wonders whether what we can do with computers today could ever have been done if the computers hadn't come, or what did people do and how did they manage without computers. But computers have done two things. Computers have added enormous new opportunity and enormous new facility. But I think it also has given us a new challenge. There is much more that we can do with technology. I can understand our commitment to ensuring accommodation in teams in terms of infrastructure, physical infrastructure, backup infrastructure, using of technology. But I believe that we could exercise further effort in using technology specifically for the purpose of helping people with disabilities. And I think that is the great challenge of our times now. But of course, as I said, attitudes and education is very important. What we are doing here today is part of that great effort. Of course, it would require, wherever it requires legislation, wherever it requires advocacy, we are all committed to it and we would proceed to do it. But seeing it as part of equal opportunity, I think, is a wonderful thought, is a wonderful idea. Not to, as in case of any other section of society, not to isolate a particular group to say, well, this group requires assistance, this group requires handholding, this group requires more empowerment, etc., which is the core really of what we have to do, but to do it by way of a generic approach of equal opportunity. So to bring people who do not have equal opportunity for any reason, whether it's a reason which is specific to them or specific to their group or is specific to their community, but whatever the reason is for equal opportunity not being made available to them, I think that's what we need to do. And when we were working on the legislation on equal opportunity, I think we ought to have kept this in mind. I'm not quite sure that we did. We were looking at various political groups, because ultimately in a democracy, it's those political groups that attract our attention. And sadly, our democracy is yet not mature enough to look at environment, for instance, or special abilities or special or case of disabilities of a certain section of our society to be treated as an important political agenda. But an enlightened leadership should look at it, even if this doesn't involve getting electoral support. And I think I would just say my presence here is to say that as a legal professional and as a public figure, I have a commitment to you. I'm pleased to be here, and in any way that we can be of part of the movement to ensure equal opportunity to people, including people with disabilities, I will certainly be there at your call as and when you want me to be there. For the rest, I would say that the experts who are here and who have and persons who have personal experience of opportunity and the lack of it, I think have done a wonderful job today in educating us about this subject. Thank you very much. I'm there with you all the way.
Thank you, sir. Thank you so much. So we'll take a few quick questions. It's already 8:08. So I can see Mr. Balasubramanian's hand raised. I'll unmute him. Anybody else has a question, you can click on the raise hand button and we'll unmute you. Or you can also write your question on the chat box. Mr. Balasubramanian, you can ask your question.
Yeah, thank you. Thanks for arranging this. It was a good session. So we are also good to see the different sign interpretation from different people. So I need to ask you.
If you could be a little louder, Mr. Subramanian. Oh, I think we lost him. Maybe we can take the next question. Natasha, I'm unmuting you. Natasha, you can speak.
Hi, can you hear me?
Yes, Natasha. Sorry,
Hi.
we couldn't hear you last time. Please.
So I'm just going to ask those questions now. I can hear clearly. Thank you again.
Sure.
I actually had a couple of them, but then my first question would be, what are we doing for persons with disability during COVID-19 times to ensure that they are being able to sustain a decent living? Is there a law that's supporting this, or Is there going to be something?
Sure. Sure. Do you have any more questions, or we can ask Ms. Chari to answer?
That's number one. The second one is in terms of tackling premises that aren't yet inclusive as per the law standard, as the date has already elapsed. The third is plans for further amendment of the RPWD Act to increase the number of disabilities from 21. I do understand that there are many invisible illnesses, but it would be good, to review it again, because if we have to look at even what the other countries are doing across the globe. And number 4 is with regards to the disability certificate without going to a government hospital right now. Speaking out of experience myself, so I wanted to check if there's any other possibility to attain it without being brushed off as you look absolutely fine or there's nothing off with you. And I know a lot of folks end up faking it, although they are in serious illness, but if people don't see it because it's invisible, there's nothing wrong with you. So is there an easier way, or is there a way where the system actually trusts you when you say that yes, you are a person with disability? Yeah, those are my 4 questions.
Great. Thank you. Thank you so much, Natasha, for these questions. Though we'll be doing a separate session on invisible disabilities, still I would like Ms. Chari to take up all these questions right now because we have her with us today. Ms. Chari, over to you. Ms. Chari, I've unmuted you. You can speak now.
Yeah. There were quite a few questions. If I do not remember, please remind me of the questions. First one was related to COVID-19. COVID-19, there is no law related to COVID-19 at the moment. Yes, persons with disabilities are finding extremely challenging. There aren't anything specific for people with disabilities for the COVID-19. The government had announced a meager 1,000 rupees, and that too is for people who are registered under the Indira Gandhi Disability Pension Scheme, which is only about 3% of the people are registered under the scheme. So there is nothing really happening for people with disabilities. The disability groups are really fighting together. They have put together demands saying we need these things to be done for people with disabilities, but nothing has really happened for people with disabilities for COVID-19. And I'm since Mr. Khurshid is here, there are a certain maybe they could help us in pushing the government to announce special packages for people with disabilities.
Is it just me, or I can't hear anything?
Sure. I think her bandwidth is low. So I'm waiting in case no, I don't think she's getting her bandwidth. So maybe Mr. Khurshid may want to add something to it on packages, and then we take the next question.
Okay, right. It's a pity that we lost her, but I think as far as the packages are concerned, these are certainly things that can be brought to the notice of the government. I know that the government's hands are very full, and the demands are enormous. But the demands of people, particularly professionals with disabilities, etc., are going to be fairly modest compared to the general demands that are being made on the government, and this is certainly something that we can push. But on the other question, I think that whether there are any laws, special laws that would apply, I'm afraid there is a clear, clean paucity of laws that seem to apply, except for laws that are that seem to provide regimentation, which is necessary in a crisis. But you need something which is wholesome in terms of rehab. And there's been, I think, some issue there under the Disaster Management Act, that disaster management of this nature and of this magnitude was perhaps never imagined could happen. There've been things like earthquakes and floods and so on, for which disaster management plans have been put into action quickly. But something which is worldwide, something that covers the entire country, I think has just taken us by storm. And I believe there aren't adequate disaster management plans in place, except to impose the discipline that we need in a crisis. But this is certainly something that could be flagged and could be brought to the notice of the government. And whatever you would like us to do, we would be very happy to do it.
Thank you.
Mr. Balasubramanian has also raised the issue of transportation of persons with disabilities during COVID times. So that's another issue that needs to be taken.
Sure. I mean, that's again, as I said, everybody has a problem. Everybody has a problem, and this is probably an exacerbated problem. This is a more difficult problem, and it should be brought to the notice, certainly, of the government. And I hope that even without being brought to the notice of the government has taken cognizance of it. But there are a few points that are emerging out of these discussions that I think could be put down on paper and brought to the notice of the government immediately.
Sure. So, Ms. Chari, the next question was about enforcement of the Act.
Right. Talking of COVID, I just wanted to highlight a few things. One was the increased amount of pension. People who have lost jobs, they need unemployment allowance to be paid to them. The law also provides for the unemployment allowance. Law also provides for caregiving allowance, which has not been announced. And disability certification. Only about 28% of the people with disabilities have disability certificate. So most people do not have disability certificate. Like it was mentioned, at least for this scenario, you cannot now go to the hospitals to get a disability certificate done, and for 78%, 75% of the people, it is not possible. There should be a method for self-identification of people with disabilities. So that people can, or it could be a local doctor, who is registered, could sign and provide at least a temporary certificate for people to access benefits if it is announced for people with disabilities. Talking about amendment, there is no discussion as of now on amendment to Disability Act. Definitely, there is a lot of scope for amending the Disability Act for adding certain disabilities. In this particular law, there is when the list of impairments have been given, there is a last category which says any other category, which means that the government can, through a government order, can add any impairment that they want. They need not go to the parliament to get added. So there is an any other category provided. So I think we should push for, those disabilities that have not been included to this method as well. Is that all the question, or if I've missed any question?
She had a question on invisible disability, but I think that was included.
Yeah.
Disability
So, yeah. So there are some invisible disabilities.
Identification.
There are some invisible disabilities which have been included, say psychosocial disabilities or people with medical conditions like blood disorders. But yes, many more impairments have to be added to the list.
Right. So let's take one more question, I guess, and then we'll have to. You can ask us questions on YouTube and we
Hello. We'll be taking one more question from Kanchan ma'am, and then we'll be wrapping up the session. There has been some issue at Sanchita's end. Thank you.
Thank you, Sanchita. Can you hear me, Sanchita?
Yes, ma'am, we can hear you clearly.
Okay.
Please go ahead.
Two questions. One to Dennis and one to Mr. Khurshid. I hope they're both there. To Dennis, who pays for the reader, the person who was with you throughout your work? Was it paid by you, or was the person paid for by your employer? And what about the confidentiality issues? Because most law firms do not want somebody with you because of confidentiality. And if Mr. Khurshid is around, then I'd like to ask him a question, but if Dennis can answer this in the meantime.
Ma'am, can you please direct this question to a particular speaker?
Hello?
Yes, ma'am.
You got the question? Did you hear my
Yes,
question?
ma'am. Can you please direct this question to a particular person, a
Yes,
particular speaker?
Yes, to your speaker from the US. I was asking her who paid for her companion while she was working. Was it paid for by her employer or by herself or by the association, the NFB?
Ma'am, she's just coming online. There's some problem in unmuting her. Ma'am, due to some technical issue, we're not being able to unmute her again.
Okay, I'm here now.
Yeah, she's here.
Okay. All right. She asked me who paid for my reader. In the case of employment, the employer paid for the reader. So once that person is an employee of the firm and they're subject to the confidentiality provisions as working for the firm. I generally did not have to go out and hire a reader to come in and read for me. And I don't know if there was one other question regarding readers, but in answer to her specific question, it was the employer. And once that person is hired, they're part of the firm and they're subject to the confidentiality agreement that the firm has.
Thank you. Thank you so much, Ms. Denise. So I think we are done with the session. It's been 8:28. We have had a great session with you all. Thank you everyone for joining us. Thank you, Ms. Rama Chari. Thank you, Ms. Denise Avant. And thank you, Mr. Salman Khurshid, for having such a great session with us. Thank you thank you to the participants for joining us today. See you in the next session. Till then, bye. Thank you.
Thank you.
Alt F4, end meeting or leave meeting. Leave meeting button to activate.